Now back to the show. This is AM 650's The Law Show.
Welcome back. Our guests from Macmillan LLP in Vancouver, lawyers Andrew Aguilar and Ryan Black. We're talking about Canada's new anti-spam law, or CASL as it's becoming known across the country. It is effective in our country on July 1st this year. It has been in the works for 10 years. It was actually drafted back in 2010. It's been proclaimed, but it's not law until this summer. So we're starting to learn a little bit more, courtesy of our two guests, about who is affected by this and who's going to enforce it all. And I guess where I'd like to start this time around is who can send messages. We talked a little bit, Andrew, for example, about exemptions and exceptions. The new rule, as Ryan said just before we went to break, is that the premise is you can't advertise to anyone without their permission.
Right.
Except or excluding, and then we get into all those exemptions. So hit us with some of the exemptions and exclusions.
Well, I think the first one is, the question is, it applies to commercial electronic messages sent to an electronic address. So it's generally not going to apply to something published generally on a website. If it's a tweet, generally, if it's not directed at someone, it's probably fine because it's not sent to an electronic address. And if it doesn't have a commercial purpose, it's exempted.
Also, a tweet to another phone, for example, is not considered an ad.
If it was directed at someone, it might be. If someone subscribed to follow my tweets,
yeah.
It probably isn't caught. But if I send to someone a direct message through Twitter, it probably is caught. So it's technology neutral in that sense.
Oh, okay.
Yeah.
All right.
And then I guess, so moving on then to what are actual exemptions. One of the first ones we talk about is family and personal relationships are going to be exempted, but family relationships have a pretty funny interpretation under the Act and exclude grandparents and siblings. It's only if you have voluntary two-way communication and, it's a marriage or a common law partnership or parent-child relationship are the only family. Otherwise, you'd have to qualify as a personal relationship, and that's a series of factors, and it's a little bit more ambiguous.
You mean, so the law, and now the anti-spam law, has some language in it which will exclude grandmothers from communicating with grandchildren? In what context? Put it in context for us, Ryan. It's sounding just plain weird.
Most emails to grandma don't have a commercial purpose,
well,
so they're
true.
Not copied by...
Happy Mother's Day, Grandma. Yeah. That's a good one, right?
That's right. But there probably are some that are. And realistically, the CRTC is not going to be going after people sending messages to grandma.
I should think no.
But for some reason, the original legislation had, a very broad definition involving blood or legal relationship, something you would expect family to mean. And this one is very narrow. And I think the thinking behind it was, well, we have this other definition called personal relationship. And if you don't have a personal relationship with a family member, if I've never talked to grandma in 30 years, why should I be able to spam her? I think was their thinking.
Okay.
But it is a unique way. I think people would be surprised to learn what the definition of family is under Canada's new anti-spam law.
And I think it almost trips us up because we keep thinking, no, it can't possibly say that. And we keep reading it and you're like, oh, no, it does.
Oh, yes. It's really narrow, Andrew.
Yes.
So what is the point of making it so narrow in law? Why would the state benefit from that kind of narrow definition?
I'm not entirely certain here. What happened when they made these, some of these were set out in regulations, and they sent out the regulation for comment from people from the legal community and from consumers and various business people, and they all sent back a bunch of comments.
Okay.
And then the Industry Canada looked at these comments and continually modified the Act, almost in an ad hoc kind of way. As a concern came up, they decided we need to increase the exemption, we need to decrease the exemption, we need to deal with these things. So, someone spoke up loudly about it, and it was changed from what it was previously.
Has there been history? I don't want to spend a great deal of time on this silly family business because it's a really tiny part of the big act. But was there a problem? Did the government see that in Canada a lot of grandmothers were being annoyed by their nieces and nephews or whatever and getting unnecessarily spammed? So we better create law or language in the act to protect these poor people?
I'm not quite. I mean, it's funny because for the lawyers that ever look at the regulations. they probably spend more time on family and personal relationships than they do on a lot of the other bigger exemptions that are available that I think most people will use. So we're not quite sure why the focus was really on that.
Okay.
I would have just broadly excluded it myself.
But I'm almost certain someone would have had to have complained.
Someone must have
that
complained.
was too broad.
Okay. So any more exceptional circumstances we should
Sure,
know
I think
about, Andrew?
some big ones that actually would apply regularly is if it's sent solely as an inquiry or application. So if you're asking someone a question about their business, could you do that? Give me a quote or something like that. Then that's a general exemption. And generally, responding to a question someone sends you is going to be exempt as well, except the one thing that's a bit strange in the Act is they've said if you're providing a quote or an estimate for someone, it's only a partial exemption. You still have to comply with CASL insofar as you have to have an unsubscribe mechanism and the information requirements that are required by the
So
Act.
if I see an ad on the internet, I'm reading a newspaper website and I see an interesting ad for a travel company or something, and I click on it and it's got some offers, and I send them an email going, does this apply in mid-September?
Right.
And they send me back, yeah, sure.
Yeah, that's right.
And is that... Now, that is a response to my generated question. So
That's right.
I've invited the response.
That's right.
So now they've got my email address, and now
Right.
I'm on their radar.
Well, they can.
What can they do with that information because I opened the door to them?
I mean, a smart response would respond to the question and then maybe follow up with a call or something to get consent, because the sole purpose of that response, the sole purpose of the exemption has to be to respond to the question.
Okay.
If you do anything else collaterally in that response, it's not caught by this exemption. So it's not like once you've emailed someone, now they have your email address and they can email you for any purpose.
Oh, you see, that's what we worry about. That's,
right.
With that internet advertising, that's why we're shy about that.
They would in this instance, if you sent them an inquiry or an application, they'd have 6 months afterwards where they have your implied consent. So even
Right.
if you didn't do business with them, if you made an inquiry,
Right.
they have 6 months where they have implied consent where they can continue
Right.
messaging.
And we're back to that nasty business of implied consent. And we have to, and the reason it's great to have the both of you here this morning, too, because this whole notion of implied consent in law is huge.
Right.
And yet, to the ordinary citizen, we don't consider implied consent in our daily business activities or just in our daily lives. And yet, it's a big deal, Andrew.
And I think it was. And, for instance, before the Act came into place, and what's existing right now is the privacy legislation, and that actually relied almost entirely on implied consent for sending messages. As long as they, informed people what they were going to do on the message, and it was a reasonable implication, then they had implied consent generally to collect your information and to send you messages
Right.
under there. So now that it's kind of flipping it to try to narrow, and focus more on express consent than implied consent under CASL. But as we've talked about, implied consent still plays a big role because that's the gateway they've used to allow people to send a message to say, can I continue to send you messages?
Right. Well, it's nasty only, Ryan, because we don't think about what we might be doing
Right.
with respect to implied consent. We simply respond
Right.
to an immediate situation.
Right.
And no, I don't want anything to do with that company. Go away. And that's it. But you send something back. And so then they have your implied consent to continue communicating with you, even if what you sent them back was, go away.
Right. Well, it's funny because you're right. People don't think a lot about when they give people their email address. I mean, I think if you give someone your email address and you don't expect them to email you back, you kind of wonder, well, why did I give them the email address to begin with?
Yeah.
I also think a lot about the free service. There's tons of free services available on the internet. You can sign up for this free account. Just give us your email address, sign up your free account. I mean, they're not doing it for free, right? Like, people aren't in the business of doing all these great services for free. They're getting something of it.
Well,
and what are they getting? They're getting your email address.
I was just going to say, when you sign up for these free apps, and there's only
Yeah.
about 1 million of those you can jump
Right.
in on, and every time you download a free app, you're giving your email address, aren't you, Andrew?
Generally, yeah, that's the requirement when you're signing up for a lot of these things.
Right. So free to you,
Yeah.
maybe, but there will be a price to pay. Generally, if you do that. If you download an app because it looks really cool and you give me your email address, should you rightly expect to hear more from this company whose app you've now got on your phone?
We think so as a business request. When they're collecting express consent to send you messages, they have to keep it separate and they have to tell you. But our position is if they're giving you a free service, they could also decline to give you that free service unless you give them their email address. Because
Right.
otherwise, how are these people going to be in business? I think is part of the give and
Right.
take. And people expect free things on the internet, I think, often because that's the way it goes. But someone at some point is spending the time and the money to put this together, and there has to be some end game for them, or the internet will be a pretty barren place.
Well, it's Ryan, it's the oldest cliche in business. There's no such thing really as a free lunch.
No, I mean, when you look at all the big apps that have gotten really successful, even the free ones, there's a big commercial component behind them.
Right.
And usually it involves collecting personal information about people, or collecting email addresses, or sending them advertisements, or whatever it is. I mean, that's valuable to somebody, and the trade-off is I get my free fun app, I get to throw birds at pigs, or whatever the app is.
Exactly.
And so that's the trade-off. And I think consumers are very focused on the free aspect.
Yes.
And they don't consider that free is free $sign, not necessarily free as in any implication at all.
Right. And anything that, now back to this whole notion of implied consent, Andrew, if we download something onto our phone, we have given the app provider consent to connect with our phone and us for 2 years, correct?
As far as implied consent goes, the one thing I think I'd want to keep in mind, though, and I'll perhaps turn it over to Ryan, is under this act, there's also certain conditions about downloading software programs that those people who are putting the app on your phone are going to have to abide by under this new act.
And specifically, they're going to have to disclose the ways that the software is going to communicate with them. They're going to have to disclose whether it's going to send commercial email messages to them. So there are other protections in the Act that are designed to protect you. You know, when you download an application on your phone and it tells you, by the way, this application is going to read your contact list or whatever it is, that's now going to be law in Canada. And we're the first country, as far as I know, to actually make that law.
Well, isn't that interesting? Because the invasion of the contact list has usually been the domain of hackers up until now, hasn't it? That's their raison d'etre, isn't it?
Right. Well, and companies, very, very famous services like WhatsApp and things like that have actually been, there's been well-publicized incidents where part of what they do to install their free application is to comb your contacts to figure out, well, who else can we get to sign up to WhatsApp? Right. And they've been dinged recently for doing that in what was, I think, viewed as a bit of an improper way.
We need to take a break here, but Andrew, this whole business of implied consent and giving permission to people simply by going for a free offer somewhere, does this cross all demographic lines? You would think the most likely to fall into the trap would be young people who just can't get enough apps, but I get the feeling it crosses most demographic lines.
Well, I think in this instance, it's just kind of how the internet works, and people understand that's how the internet works. They expect that most things are going to be free on the internet when they're doing it now, and people are going to be signing up for these services. You know, if we're talking about fighting spam and you don't want spam, one of the best ways is probably to stop signing up for as much free stuff and downloading things off the internet.
That's right.
You know, that's where people are usually getting your email addresses. So if you don't want it, then don't go and download all these free things.
Or use a dedicated email address. I have an email address that I use for just signing up for things.
Right.
So all the spam goes there, and I get a ton of messages there every day. And actually, just because I'm interested in the area, I unsubscribe to all of those things just to see how many of them are actually legitimate unsubscribes.
Just to go back a couple of decades before telephones and emails and all the rest of that, when we used to go to things like the Home Show, we would go up and down the aisles, and everybody had a free draw for some, and you fill out an entry form and you stick it in the barrel, and that gives your name, your address, your phone number, and by gosh, if just a few short weeks after the Home Show, you didn't start getting just reams of advertising from all of those people whose draws you thought you'd signed up for. Well, that technology has replaced all of that signing up and putting things in the entry drum, but it's exactly the same principle, isn't it?
It's actually explicitly in the Act. They've talked about it's the business card rule. If you've given someone a business card, and I assume if you put it in the bowl on their table,
that's right,
you've given them a business card.
Definitely.
You're allowed to contact that person about whatever their business is one of the implied exemptions under the Act.
But not signing up for, like, if I just wrote my name on a card and put it into a draw, that doesn't necessarily give them consent to email me for a commercial purpose.
Interesting. So it may be different from the old Home Show days.
I think it is. I think they've actually addressed the Home Show thing.
Well, good stuff. Well, sometimes people have got around to doing this. They've been taking advantage of us for a long, long time. We're talking about Canada's new anti-spam law with our guests Andrew Aguilar and Ryan Black, lawyers from Macmillan LLP here in Vancouver, on this very special Mother's Day edition of The Law Show, and we're back with our final segment in just a few moments.
This is AM 650's The Law Show. There's more of the show still ahead.